At about 10, today is this court, accompanied by Ndiangui. Very big fear for his life. He expressed, yes. And therefore, because I would like, and I request this honorable court to grant the family and myself, we have all met in court when I was meeting him, to grant time for us to be able to talk to him in confidence and in privacy. And since he still appears to be very traumatized, we urge that any time in the course of next week, we will be given an opportunity to come back to this court, accompanied by him, so that he is able, and ourselves we are able, to be of further assistance to the court. I regret the fact that I cannot be of further assistance at this stage until we have had a proper session with Ndiangui Kinyagia to know exactly what was happening during those traumatizing events. So that's all, my lord. My lord, Mr. Ndiangui, please stand. That is Mr. Ndiangui.
Make your way here.
Make your way here.
Lord has makes his way here. Just for clarification, and what my learned senior was talking about, the affidavit indicates that the deponent was contacted on Tuesday, not yesterday, so for the correction of the record.
Yes, I've seen what you say. You now need to record me.
Yes, Your Honor. In any case, it's beyond the basis of the affidavit itself.
Yeah, that's what I'm saying. I've seen it. So, what will you say?
I will just point out that correction.
Second petition. Contacted. Yeah.
Tuesday evening.
Tuesday was fast.
Yes. First of July. It's going
You appear to have beards. You can take your seat. So who else wanted to say something? Petitioner's counsel?
My Lord, still, now that the DCI is here, there are issues about with these cases are becoming about modus operandi because these cases are becoming so many. And directions of this court, after listening to the answers the DCI may give, may help save the court the time we have spent. So we are seeking your indulgence, but now that the DCI is here, we at least can deal with matters of compliance today. And any other procedural issue we can reach clarification from the DCI. I want to say an application like this comes to court for the rule of law and for the safety and well-being of everyone. So we'll be happy to proceed with the DCI.
Senior counsel, I look at my direction. And I want us to look at it. You are very clear.
I have a copy.
Yes, you are very clear on what I wanted. This is your problem. We are here only for one subject.
I'll read number 5.
I'm aware. I'm aware of my directions. I'm looking at the subsequent directions. But I should last time over here. Why I need them. Why I need them.
Okay, yes, I'm seeing now number 5.
So can you go
This is
beyond
not the one. So the one with
Mr.
that
Kibe?
Yes, Madam.
Can I go beyond what I wanted this morning?
I believe that whatever he has been is subject to the directions that were made, but I cannot say.
Because you've made a specific request
Yes, I have.
and you want to participate.
Yes, we
Kind
like
of
to.
okay.
Yes, but the petitioners can speak for themselves.
I agree.
Yes.
I have the petitioner, second petitioner in court.
Yes, the second petitioner is in court.
I wanted him dead or alive.
Yes, that is.
I have him alive.
Yes.
What else do you want me to do? Once I have him alive. You have requested a renewed time with him,
Yes.
and it's important. So, senior counsel, I think I'm not deciding. I think the fairest thing to do is to allow the family and you lawyers have a conversation with the second petitioner. And then after you have that conversation, then we will decide how to proceed next. My intention this morning was to have it, and I have it. I present him to the Kenyan, and he is here alive. So any other thing is now after you people take questions. Am I right?
we are most obliged It's just that we thought we could take advantage of the presence of the DCI, because apart from that, there were compliance issues. Let me just finish. There were compliance issues which we raised on the
We are not doing the petition. I still have the petition to dispose of.
Okay, then with that I will see.
We are the preliminary stage, we are looking for him, we have to.
And we are relieved.
So can we still have a petition to do, Mr.
Yes, my lord.
Abata.
Abata. In fact, my lord, we still have a petition to give.
Yes.
And in the interim of that application, they agree that the second petitioner applicant has been found. From our position today, we have come to dine, and our friend is here. And
You object
I am saying, my lord, we had come to dance. Since our work as lawyers and our witnesses in court, we may miss this opportunity. It is a golden opportunity. I am reading this in line with what was found in by your brother Justice Mugambi in petition E436 of 2024 and your brother Mwamuye in E0714 of 2024, that orders of the court are not pious orders. They have to be complied with. Now that the director of criminal investigations is here, there may be questions that we may need to ask to prepare ourselves in the debrief that we come to explain to court. He may elect, as we have seen before, my lord, on the day when, and his brother, Mr. Masegeni is here, on the day when the court wants to exercise its prerogative power, the petitioners are usually found. It is a modus operandi. Every time when they are almost getting to the court, the petitioners are found. Now, since the director is here, my lord, we intend.
No, I will give direction.
Yes, my lord.
You are making requests.
Yes,
I will give direction. But I want first to take into account the request of the family.
yes.
It's paramount to me.
Absolutely.
We want to talk to the second petition. We still can ask him to come. But if you want to ask him questions, I'm here, he's here.
And your directions, my lord, are very well noted and comply with.
No, if you want, he's here. And I'm here.
My lord, just if I may be able
So
to.
let's have it in order. That we have the DCI, we have the petition. Right? The person I wanted.
Yeah.
You want to ask him questions? He's here. I'm not telling you no. I wanted to agree how we proceed. As the family have first opportunity to talk to him, there may be something.
I'm actually drawing from your wisdom, my lord, that in this particular instance, as we left last time, the primary concern was the life and liberty of the petitioner, second petitioner. And we are glad that he's here. He's alive, he's breathing. At this point also, Mr. Min has acted complying with the orders, he's here. And on the petitioner side, we were ready to cross-examine him. But the family made a request, which is also reasonable. We have a traumatized citizen who, for all intents and purposes, may be in a daze not even fully understanding what we are saying or going through. The request to be brief, give him time to compose himself, to understand the circumstances under which it could be traced. Then we reconvene. Once the second petitioner has been briefed with counsel, probably gotten medical attention, and is ready now to participate in the petition, all parties come back here. And my lord, the only point you are stressing, which now I'm guided again by your counsel, is the presence of Mr. Amin. We may need him. My vice president, I as deputy designate, Right. Would have wished it happens today, but in the circumstances, it may not be possible.
Oh, he's here.
No, I'm talking of,
And we are here.
and I was going to say, my lord, I was actually coming to that. And also recognizing that he's in charge of criminal investigations in the entire country. And getting him is sometimes difficult. And now that he's here, at least to the extent of the first petition as cancelled, we can take our bite at the chin when it is still fresh and here. And we question him, we preserve that we don't fall of instances where when we seek him to come to court, he says he has gone for an operation in Paraguay. Which may be a genuine operation, or not genuine, as sometimes happen. So having blocked his diary for today, no prejudice will be suffered if we proceed with him today. But if the court is minded to consider the family request, we'll equal together. And also, my lord, of import in this particular instance that we don't lose focus on.
Yes.
In the replying affidavit signed by the respondents in paragraph 20, the question,
I have which have to.
the affidavit sworn on 30th of June 2025 by Samuel Itake.
Paragraph 20.
Paragraph 20. There's a live issue which I will not wish that will be lost over. If the second petitioner were to leave court today, there is a real danger that he may be arrested or detained by the respondents. On his behalf and in the interest of justice, I pray that when the court is making directions as regards to the second petitioner, the court consider issuing an order restraining his arrest. If any arrest ends up in court, and he can be bonded to attend to this court when required, so that the question that should be of a primary concern at this point is him getting medical attention and social support.
In fact, my lord, we'll be happy if the director will just tell us that we will not arrest him. That we go just probably just also for the court to feel the presence.
I confirm the application for protection of the second petitioner this time. This is also one you are going to make. So I ask you to take it in giving these directions.
Yes, Mr. Bitter.
Yes, my lord, thank you. I don't have an application to make. First application which to make forward is that the court will be gracious to summon the diplomat who swore an affidavit in support of the petition, one Florence Muturi, to attend court during the next hearing for us to examine. Because, my lord, there are certain facts that should be divulged to that have led us to
Which
this.
affidavit?
There are two affidavits. The first one was sworn on the 1st day of July 2025. 2025.
Which date?
1st July 2025. And there is another one sworn on the 24th day of June this year.
So, Mr. Bitter, you should begin sequentially. Hurry up to the latest.
The first one is sworn
24.
day of June 2025.
First.
Yes, that is the first affidavit. The second one, my lord, was performed on the first day of July 2025. Both in support of the petition and the motion. secondly, my lord, in terms of the directions of the court, my lord, now that the DCI has come, once it was summoned, pray that those directions be discharged as regards the appearance of the DCI. And thirdly, my lord, the DCI, in light of what has been stated, would wish to be given an opportunity to speak on behalf of the directorate. Because
To have an opportunity.
to address my lord on behalf of the directorate, because they feel that they have not been treated fair as regards this case, and they need to be heard. An opportunity to be heard as regards all the issues raised. My lord, fourthly,
So I didn't get you.
yes, my lord, he wishes to be heard. Wants to be heard.
Today,
Today, my lord, before you, now that you've summoned him, wants to be heard because they have not been treated fair.
they say so.
Yes, they need an opportunity to state the facts. My lord, an application has been made orally. I am not privy to the basis of our application.
Which one?
The one for, there were several applications made by Mr. Kibe and Mr. Okabata.
Yes.
Yes, and Mr. Willis Otieno. I pray that we make a formal application so that we have an opportunity to respond.
You are mixing up.
My lord, I've addressed you
Let
first.
me see whether we are speaking.
Correct.
Mr. Kibe made a specific request on behalf of the family that there would be one time with the special petition. That's number one, and that's the primary application I have for Mr. Kibe. So what do you say to that?
My answer
Don't
is
mix his
yes.
and the other people.
My answer is simple. Mr. Kibe is not a party in this proceedings. He is not a party in this proceedings. I have no problem with him meeting the second petitioner in whatever capacity. But he is not representing any party in this proceedings. If he was, I would be in a position to respond to an application made by a party.
So you're not able to respond.
My response is Mr. Kibe is not a party in this proceedings. He cannot make an application in proceedings that he is not a party. It has not been done. There is the application made by Mr. Willis Otieno. And I believe, Lord, if you look at the notice of motion, filed by the petitioner.
Yes.
There is a prayer that was sought for the unconditional release. And prayers of habeas corpus, Lord. If you look at prayer 8, Lord.
That's in the original motion.
It is in the notice of motion, Lord, the one that gives direction.
Yes.
dated 24th of June. You've seen it, Lord?
Yes.
Yes.
Which one are you referring to?
I'm referring to prayer number 8, Lord.
Yes.
Prayer number 8. So that, my Lord, this is the prayer that has been sought. We have responded to this motion, Lord. And we are ready for it to be urged, Lord, inter partes. And I believe it is only fair that we deal with this motion, Lord, before we consider any other oral application. I believe that you're coming for directions, my Lord, so you can give directions from here, so that we conclude with this introductory application. And that is my brief response.
My Lord, in response,
Before you respond,
yes, ma'am.
I want to find out whether I got Mr. Peter. What you say, Mr. Peter, is
Yes.
that you want the DCI to be allowed to speak.
Because you called me.
Because,
Come on.
yes, yes. I'm not saying like this. Why are you here?
Yes.
That's all I want to hear.
Yes.
Because the petitioner, the family has a specific request. The petitioners, counsel for the petitioners have their way of looking at things. So I want to know whether you agree with that we hear him today, despite the request from the petitioner's family.
Despite the request, my Lord, because of the schedule.
So I have no problem. I just wanted to know whether that's the way you want us to proceed, so that I give directions.
Yes, please.
Mr. Ndiangui?
Yes. My Lord, first of all, it is very strange for the Honorable Attorney General, presented to the Attorney General, the Constitution in Article 156 of the Constitution, I believe sub-article 6, talks about the Attorney General shall promote, protect, and uphold the rule of law and defend public interest. This is a habeas corpus application, the subject matter of the petition.
Yes.
In a habeas corpus application, and by the nature of habeas corpus, the family is a necessary party, and invariably habeas corpus application are instigated or instituted at the behest of the family. And therefore, for purposes of these proceedings, where the second petitioner is indicated as Ndiangui Kinyagia, was not there to give the instructions, that should be construed as the family of Ndiangui Kinyagia. So the family of Ndiangui Kinyagia is already a party. And if it was not expressly It is a necessary party whose right to participate is inherent in the nature of habeas corpus. But if for whatever reason it is necessary to comply with technicalities, notwithstanding Article 159 of the Constitution, that litigation, particularly under this jurisdiction, shall not bear regard to undue technicalities. I wish, pursuant to Rule 10, Sub-Rule 4 of the Mutunga Rules, to make an oral application for the family of the second petitioner to be added to the proceedings as a third petitioner. But the primary position is that they are already parties if the second petitioner is a party. And that is pursuant to Rule 5. Is it Rule 5? Rule 5 of the Mutunga Rules. And this court has jurisdiction under those two rules, 5 and 10, to make such an order. And my lord, the last one is a question of common sense and propriety of proceedings. The notion, as urged by the Attorney General, that you can have proper habeas corpus proceedings in which your lordships can lock out the families and their representatives from speaking would be completely unusual. The only issue that we need to clarify is that when I advised that Lilian Wanjiko Gitonga to file an affidavit, I advised that she would come as an interested party. So for purposes of Lilian Wanjiko Gitonga, who gave us the information, will appear as an interested party. But now that he is there, and when we speak to Ndiangui, the second petitioner, then we would be able, for purposes of completion of the habeas corpus proceedings, to be of further use as are litigated to the court. Because all of us, even out of curiosity, want to know where was he? And why has he also just appeared the day before? We want to know that also. If nothing else, for purposes of curiosity. Therefore, we need to talk to him, as we had requested, but we can formalize the proceedings because we need to apply for his protection. We must apply for that.
Madam, do you have a right to reply on the application?
Which one?
The question of the liberty of the individual and the need for him to be given an opportunity to get medical attention. He looks physically traumatized. I'm not an expert, but applying my elementary knowledge of
So
myself.
if you continue talking, he wants medical attention, what are we going to do?
That's exactly what I was going to say, that we should not talk too much, but we should by issuing the order that allows his liberty and an opportunity to access medical help.
Where I am, I think we are losing the point. I have the DCI report. I have the petitioner report. The family has requested to have a conversation with the petitioner, second petitioner. parties who want to keep this here. We want here the DCI, Mr. Peter says they were not treated well. He will tell us. The other side wants to examine the DCI. So how do we proceed? Which one should we give preference to? It is something, a decision we have made conscientiously. If the health of the second petitioner is primary, or do we keep the DCI here?
My lord, I think we should give way to the family, and parties, those who are needed by the court can come on the next date. The application was about the well-being of the second petitioner, and I think in all fairness we ought to give way, even though we were rallying to go, we should hold our breaths.
Mr. Visitor,
Yes, my lord.
how many documents do I have? I have 3 affidavits from William. Is that Mr. This one, third, second, attendance, first one, that's good. It seems to be the same.
No, my lord, there are The first affidavit by someone today.
That I have.
Yes.
That's the original.
Yes, that's the original.
That one we have.
Then we have a second, a further replying affidavit by Leonard Siago. That one is sworn on the 2nd day of July.
So is that one of William?
Yes. So there's Leonard Siele, and then there's Patrick Will.
The first one is?
The first one is by Samuel Kuti.
Yes.
That is the first one.
Yes. Yes.
The second affidavit is by Leonard Siele.
Not have that one.
We don't have it.
The third,
The third one is by Patrick Will.
have 3 copies by Patrick Will.
Maybe they printed the same thing. But we supply, we have copies of it.
Let's check. Did you upload the one on Sierra?
Mr. Marwa actually uploaded it. He's here, I can speak for himself. He personally uploaded
No, we are now the lead.
it. Yes, ma'am.
I told you are his senior.
Yes, and I trust him.
So how do you throw it back to him? Because you are the one, I'm looking at the system.
Yes.
It is the same affidavit by Sweden that was uploaded. It was uploaded twice. Someone else who can assist me, maybe we are wrong.
this case.
Your Lordship, there is I've given a physical copy right now.
No, it has to be here. So this is the file. Your people can upload it now. Let's see the have you seen the one by 7?
Yes, my lord.
One by 7. You don't have it.
My lord, he can re-upload it. So that we don't-
Yeah. We are still trying to confirm what the systems are. Yeah, it's here that you uploaded with it twice. I'm sure it is because of the urgency. So anything else?
Lord, I wanted to address your question on an issue that Mr. Peter has raised that my senior Mr. Superior sees important as better. He's 38 years in the profession, my Lord, and to me that counts for something.
Please, my lord, leaving what my vice president has said, I am the second senior most after senior counsel Karua. I just wanted to bring into context on the 4 applications made by Mr. Vita. The first one was on the summary of the CEO of the Law Society. I appear for, together with the rest, for the Law Society and the second petition. As to that application, the Law Society has no objection in respect of the first application by Mr. Vita on the question of process innovation. We can be dealt with at the appropriate time. What I am worried about are the second and third applications by Mr. Vita because they go against each other. The second application was to discharge the personal appearance of the DCI. But the third one is to give him an opportunity to address court, which is sort of supporting what my other learned colleagues had said about having a bite at the cherry today. So that third application also supports what the other parties were saying, that he can be able to say something. You cannot just say it and go. He may have to be asked some questions in relation to that before his discharge. So while dealing with those 2 applications, you may have to consider how to balance the 2 of them in relation to having given him the opportunity and then thereafter discharging him and whether he will be cross-examined. Then as to the question of a formal application being filed by Mr. Kibi, I think that has been addressed, and that was the 4th link of Mr. Vita's application. So those are the 4 issues I wanted to bring to context for purposes of then when your lordship is giving directions, then you can be able now to balance what Mr. Vita requires, what we also require, and the fact that at a later stage, since the other affidavits are supporting the petition, they can be dealt with in the main petition, and the deponents, including whoever may be required, a notice can be given as is required by law that we will want to cross-examine you on these allegations or these depositions in your affidavit dated this particular day. That will be all.
Let me make it clear that the court is never addressed. It's the lawyers who address the court on specific items. So if the DCI wants to speak, we will take to the witness box. He's here as a witness of the court. He's led what he wants to say, and then he will be subject to cross-examination.
Thank you.
Those are the directions. If we are doing that thing, we clear the way for that. Bearing in mind, they have a specific request from the family.
Yes.
So if you want us to go that way, we take the stand, be led for the reasons that the court directed you to hear, nothing more.
I think my learned senior, my learned counsel can be able to now.
So you look at the directions at issue, you will be here for a specific mission, you are not addressing any other issue. If we are sticking to that, that's what we are doing.
Yes, but let me address you on that, because obviously there are some instructions from the client. He says he wants to respect the wishes of the family. Now that he has answered from the summons of the court to appear, and the second petition is present, that you're discharging, because that those summons have been paid.
What is he telling you?
No, he's telling me to abandon the other applications.
It's already on record, and all of the applications are already on record.
So as regards this time, my lord, is that in discharging, doesn't wish to pose the wish of the family. Those summons are actually expired.
A lot of that application, when Mr. Bita will be given an opportunity to reply.
Mr. Bita, you have filed all you have filed in response to the petition.
To the petition, no. I was just dealing with this aspect. Because you know there are other parties. The accusation against other parties.
So you have not filed responses to the petition.
As regards the other parties, but as regards the IG, the DCI, both in their public and private capacities,
You have filed.
Yes.
And those are the primary parties.
Those are the primary parties.
So where my concern is there any other thing you want to file in form of a response?
I will file grounds of opposition on behalf of the other parties that are not primary. The Attorney General or the Cabinet Secretary of Nigeria. But today is Thursday. By Monday, I will file it.
You have filed. I'm suggesting that we go directly to the petition.
That is okay.
You agree? Petitioners?
We're fine with that.
Well, I can also file an appeal.
That's a response, Mr. Bita.
Yes.
Ask Mr. Maro to come to my take so often. He knows our responses to the petition.
I'm not a bit, you're quite longer than Mr. Maro.
I don't know when last year. But I'm sure you know.
Yes, madam.
So next week, so I can give you 7 days.
Yes, my lord.
Senior counsel, I restrict submissions to 10 pages. How many pages would you want to have?
I think then
10 will do.
would do, yes.
We are
What
dealing
one,
with the petition because there are specific issues.
then make it maybe 15, 15, yeah.
Mr. Peter, would 15 be fine?
More than that.
My lord, before you give your directions, perhaps you consider that the case be disposed by both submissions and viva voce evidence, because we still have that for the examination.